Welcome to the Regulatory Transparency Project's fourth branch podcast series. All expressions of opinion are those of the speaker.
Good day. Thank you for joining us. My name is Brent Skorup. I'm a legal fellow at the Cato Institute, and we're very grateful to the Federalist Society and the Regulatory Transparency Project for hosting this discussion. I'm very pleased to introduce a three-part series about aviation regulation and reform. This is a timely topic for as a result of many things going on in aviation, one of which was a few months ago, a mid-air airplane crash between an American Airlines regional jet and a U.S. Army Black Hawk helicopter above Potomac in Washington, D.C., about 1 or 2 miles from where we are sitting right now in the Federalist Society offices. But also other longer-term issues like air traffic control, labor shortages, and as of right now, there is no FAA administrator, although the Trump administration is working on getting an administrator approved. But all that to say, for many people in DC and in the public, there's been some confidence lost in aviation regulation, and with the new administration, it's a good time to assess and plan ahead. So we've got a few episodes to release. The first is today about drones and federalism, and just the technology shock of having hundreds of thousands, if not millions of drones, if all goes well, and just what that will do for federal and state regulation. Another episode will be about advanced air mobility, so-called air taxis, and drones, and how the FAA will regulate technology. And then another episode about air traffic control and FAA reforms broadly. But as I said, today we'll be talking about drones and federalism, how the federal government and states can and should regulate drones. I'm very pleased to have with me Reggie Govan, who was Chief Counsel of the FAA in 2014 to 2017 during much of the Obama administration, and Charlie Trippe, who was Chief Counsel of the FAA in 2017 to 2019 during the first Trump administration. And they had a front row seat as drone policy was being shaped at the FAA. So thank you, gentlemen, for joining me, and we'll dive right in. Reggie, I'd like to go to you first. So we have this technology shock. The average listener probably doesn't follow aviation closely, but there are a lot of drone pilot programs going on. Drone capabilities have improved a tremendous amount in the past decade. And now companies and regulators are starting to dream of a world where you can do long-distance drone services and increasingly autonomous drone services. However, with these small drones, we say small, but these are not toy drones. They can be 10, 20, 50 pounds carrying cargo. They fly at low altitude airspace, and that means there are new issues for federal regulators, but also for state regulators. Can you talk about the nature of the conflicts that you foresee, that you've seen when it comes to the FAA's role, and why that might be in tension with some state priorities, and to the extent there's also landowner issues? Reggie.
Yeah, we truly are on the cusp of a very significant expansion, probably to scale, of commercial drone delivery operations. We've, for the last 7 or 8 years, been very much in a testing mode, where there have been a series of demonstration projects for which the operator has to get specific regulatory authority for a specific operation, which has been a point A to point B delivery of one thing or another, usually some form of grocery product, household goods, and medicine. And as a result of the last 7 or 8 years, a company like Zipline has done 1 million deliveries, domestically and internationally. Walmart is on the cusp of a major expansion of its delivery services in 5 states. So we are there, and the question is, what issues are going to arise as a result of this significant expansion to scale of drone operations? And those issues are many, And secondly, what agency should be adjudicating the various competing claims that arise? The primary claims are, first, who controls low altitude airspace? Is it the property owner, the landowner, or is it the FAA operating in its paradigm as setting rules and regulations for the use of all navigable airspace? And as a result of the advent of drones, low altitude airspace for the first time is essentially navigable airspace. And then there are a series of claims that are most aptly illustrated by a recent experience in College Park, Texas, that has been written about both at CNBC and Wired Magazine as recently as March of 2025, where Amazon had a very significant commercial drone delivery operation. It was approved by the FAA and had buy-in by the local community. And yet, the scale of the operation and the specific drone, the aircraft being used, for a lot of the residents, either adjacent to the delivery facility or on the route that was being followed by the drone, complained repeatedly of significant noise, analogizing it to either a buzzsaw or to a beehive. And so these citizens advocated both at the community level with the mayor and the city councils, as well as with Amazon, that there had to be some change. It was intolerable, the present situation, even though it had been fully approved at all levels. And so the real question is, when you have an issue like noise, or you have micro weather patterns that may affect significantly the safety of that airframe, the drone, where should those claims get adjudicated? And right now, all claims are being adjudicated at the FAA in Washington, D.C. And I certainly have a view, and I think Charlie shares a view, as do some others. It's not necessarily a majority view, it's not reflected in present law or regulation, but that state and local governments ought to have a significant role, a carefully and specifically defined role, but a specific role in adjudicating claims around the use, unintended consequences, and the like of low altitude airspace.
I'll turn to you, Charlie, for your response as well. But and just for listeners' benefit, when talking about low altitude airspace, federal rules generally require small drones to fly below 400 feet to give a buffer to traditional manned crewed aviation and planes. And the commercial drone companies that are out there, I think it varies depending on the company, but I think Amazon drones cruise at about 160 feet. I think others are somewhat higher. I think Zipline is around 300 feet. But as Reggie indicated, for many residents, particularly if you're in a rural area, the noise can be considered annoying and disruptive. But yeah, Charlie, to you, what can you speak about? The reality that there are kind of conflicting and intention priorities here between landowners, the FAA, and state governments.
Yeah, just to add a little bit to what Reggie said. First, I mean, the states and local jurisdictions do have authority over some activities that are carried on by people operating drones. I mean, the traditional police power is still intact. So if a person operating a drone operates it recklessly and so as to endanger an individual, that could be prosecuted under state law. If a drone operator flies within a foot of a person, for example, if a drone operator with a camera-equipped drone is, peering into a home in violation of state law or local law, the state or local authorities could take action on that. So it's not that they have no authority as to drone operations. They have plenty of authority insofar as it's cabined in the traditional police power, number one. Number two, we're kind of returning to a set of issues that were first raised during the early days of heavier than air flight. I mean, when airplanes first appeared, people had big questions about, well, who owns this space in which they're operating. Are they trespassing when they fly over us at 10 feet, 100 feet, 1,000 feet, 10,000 feet? And those questions were largely resolved by the end of the 1930s, by the time the 1938 Air Commerce Act was passed. But because of the context, which was commercial aviation, basically, didn't really change between the 1930s and till, say, 10 years ago. So those issues were resolved through dormancy. There weren't the only people who were really being affected by the operation of airplanes near the surface were the people who were living near larger airports. So, you have to kind of keep it in that perspective.
A significant part of the resolution of the issues that Charlie was talking about is a 1946 Supreme Court case, the Cosby decision. And there the court, for the first time, was adjudicating the claim between the government's use of the airspace, in this case military aircraft, to take off and land, and an individual, Cosby, who had a chicken farm that was in the flight path. And he sued because 150 of his chickens died, and he had to abandon his chicken farm because of the significant substantial noise interference. And he asked for just compensation, arguing that the overflight of his property was a taking of his land, into which under the Fifth Amendment he was entitled to just compensation. And the court had no difficulty in deciding that, first, the ancient maxim that the landowner controls all airspace up to the heavens and all the land beneath the earth was no longer applicable in the age of aviation. And instead, they vitiated that maxim and said that it's most navigable airspace, or all navigable airspace, is a public right. However, and explicitly, the landowner exclusively controls the airspace within the immediate reaches or envelope of the land. And so it's a two-part holding. And it's the second part that has really been drawn into focus as a result of the development of commercial drone operations. And it's that part that we believe needs to be focused on and renovated. My view is that the commercial drone industry and the FAA generally has not given sufficient paid sufficient attention to Cosby and its implications for authorizing through regulation commercial drone operations that will fly over countless parcels of private property. Charlie, you might want to say a word or two about where the state of Cosby in the last 15 or 20 years, how the agency has responded to it. Well,
it really hasn't responded to it specifically, I think. I mean, it's the FAA has taken a regulatory approach which has relied heavily on the proposition that it regulates air safety virtually through the entire airspace. We can probably leave it there.
So, I mean, it sounds like, correct me if I'm mischaracterizing Cosby, but the Supreme Court articulated a view that there are at least two types of airspace. There is kind of high altitude airspace where most planes cruise, and this is some sort of public thoroughfare where federal regulation can be predominant. But then there's this immediate reaches tied to land where landowners have some sort of exclusive right to that airspace, and let me know if I'm characterizing that. Yeah, Charlie, go ahead.
Cosby's a takings case,
right?
And
right.
I suppose the court could have gone, and I think this was suggested in the dissent. It could have gone in the direction of resolving it on the basis of a trespass, but that isn't how Cosby was structured. Cosby is a holding that there was a taking of this individual's property by the government because of these low altitude flights.
Right. And so in today's parlance, we'd say it's a regulatory taking. The federal government exercises regulatory authority and authorized flight paths that interfered with Cosby's use and enjoyment of his property. And the flights were at a low enough altitude. In that case, I think they were down to 83 feet.
Something like that.
That it was a low enough altitude, which is why it's relevant today, because drone operations, by definition, are in low altitude airspace. With the exception of takeoff and landing in Cosby's days, planes were just traversing low altitude airspace to get up to the higher altitudes to continually operate. So now with drones, for the first time, we have navigable airspace that is low altitude. That wasn't what the court was contemplating at the time.
And you asked about how the FAA, sort of dealt, or maybe Reggie did, how it's dealt with Cosby. But really, as a practical matter, the takings case or the takings aspect of operations around the airport have been resolved in the commercial aviation context by purchasing rights from nearby landowners, so-called aviation rights, that allow planes to approach the airport and depart from the airport at low altitudes. So other than that, the FAA, I don't think, has set itself up as an arbiter of property rights, trespass, or takings in general. I mean, it hasn't had to do that in order to carry on its regulatory functions.
Right. And what's important about aviation easements is, first, our airports are owned and operated by state and local governments or governmental instrumentalities, unlike the operation of drones, which can take off and land almost anywhere. But Charlie previously raised the point around states retaining plenary police power. One of the aspects of that police power is the ability to control where any aircraft, including drones, will take off and land. And there's nothing that the FAA has done that even suggests that they're going to interfere, limit, or constrain state and local governments in regulating the takeoff and landing of drones. What we're really here talking about today is the operation of the drone in the low altitude airspace.
Which is analogous to how commercial aviation is regulated, in the sense that the Airline Deregulation Act of 1978, which generally precludes the states from regulating route service and fares, leaves intact the power of local and state governments to operate airports and to determine where they should be located.
Okay, so
On one other point, Brent, sure. just to sort of fully set the table, so to speak, by the end of the 30s, Congress had also made it clear that U.S. citizen has the right to transverse the airspace. So there's a right to use the airspace as to every citizen.
So in Cosby, these planes were flying at very low altitudes as they landed, and the Supreme Court, did not base this entirely on trespass grounds, but did recognize some landowner airspace, the immediate reaches that landowners that's tied to the land that looks like
that's
real
how
estate.
that's how they phrased it in the context of, as Reggie points out, a regulatory taking. That the land was not seized by the government; its utility was diminished by this governmental activity.
Right, and okay, and that brings us to today. You can't discuss aviation and low altitude airspace without talking about the Cosby decision. It's just a seminal case. But there was, I don't know let me know if you disagree with this, but there was an equilibrium where airports got the land they needed to do takeoff and landing, and commercial planes and even small jets and general aviation are flying at altitudes typically that do not interfere with people's enjoyment of their land. But drones are different than traditional aviation in a lot of ways, one of which is that they fly at very low altitudes, and for many landowners there's an intuition that they own the airspace above their land. I know there was polling done a few years ago by YouGov. Something like 85% of polled people believe that they had a right to exclude drones from the low altitude airspace, although there was a lot of uncertainty about what altitude their property rights diminished. All that to say, there is this intuition. I'm not, it's not entirely clear in Cosby, at what altitude someone's property interest diminishes. Does that sound about right?
I think that's right. I mean, there are probably 25 scholarly articles written by academics and other practitioners, and there's a general consensus, maybe around 400. Some adopt 500. Some go as low as 200, even 100. So there's a range of altitudes at which people feel it's reasonable to draw the line between the navigable public highway and the private right of access. What's interesting in this area is the FAA has recently responded through a fact sheet. There have been 2 fact sheets in the last 10 years, one in 2015. The 2015 fact sheet was really just an attempt to put the world, if you will, on notice, the United States world, state and local governments that were beginning to enact a series of restrictions on drone operations, to put those governments on notice that there are very substantial federal equities, and you should come into the FAA and consult as you're working through your legislative process in the state and local level, so that you don't run afoul of the federal equities. Fast forward to today, and I guess a year ago, there was a revised fact sheet that the FAA put out through the Office of the Chief Counsel. And that fact sheet is the first time that the agency has recognized in writing explicitly the validity of Cosby, and has essentially adopted a significant part of its rationale, even though I think it departed in an equally significant way. But within the FAA for the last decade, in response to drone operations, there's been a concerted effort to assert federal authority down to the tops of blades of grass, which essentially is saying drones now operate in low-altitude airspace, therefore low-altitude airspace is navigable, and all navigable airspace is within the exclusive control of the FAA. We believe...
At least as to aviation safety.
Yes, yeah. We believe that that's explicitly counter to Cosby. And so the most recent fact sheet of the 2024, I believe, fact sheet recognizes the concept that the landowner has exclusive control over the airspace within the immediate envelope of their property. That's explicit in the fact sheet for the first time, which to my mind is a explicit repudiation of the assertion of exclusive control by the agency of airspace down to the tops of the blades of grass. However, what they say is that in order for state and local governments to respond to the use of those low-altitude airspace within the immediate reaches of the property, there has to be a substantial interference with the landowner's use and enjoyment of that property. I believe that's a misreading of Cosby. The Cosby facts, there was a substantial interference with Cosby's chicken farm. It went out of business. But I don't believe that's the holding of Cosby. The holding of Cosby is there has to be an immediate and direct interference with use and enjoyment of your land. And so I think the fact sheet both adopts Cosby's, recognizes the validity, the good law status of Cosby for the first time, but also then significantly compromises its utility as a basis for state and local governments to begin to regulate, in my view, some very legitimate interests under their police power.
Of course, the fact sheet, this one that Reggie's addressing and the earlier one, are guidance. They're not rules and they're not law. I mean, that's the view of the leadership at the FAA.
Okay. Yeah. In the FAA, some of these documents are somewhat hard to parse. I mean, Cosby itself is in some respects somewhat hard to parse. Yeah. Let's. I want to turn it to the state side for a little bit. Many states.
Before we do that,
sure,
can I
go
just
ahead.
update us?
Yep.
There was recently in 2023 a Supreme Court decision that dealt with the taking by regulation, and that is the Cedar Point Nursery versus Hasid case. And there was a regulation, California regulation, that guaranteed union organizers access to commercial property for purposes of talking to the workers and the employees. It was a regulation that basically said you had a right to be on the property for 3 hours a day within a 30-day period.
Government regulators, right, had a right to
The union organizers. Union organizers had a right to access a commercial tomato farm property 3 hours a day within a 30-day period for no more than 120 days in a year. And it was challenged as a taking. You are appropriating, the government is appropriating by regulation the owner's property for a public purpose, the public purpose being union organizing. And the court struck down the regulation. And it did so in ways that I think are really illustrative of the issue that we're talking about today with respect to low altitude airspace. First, they said that the use of the property doesn't have to be permanent nor continuous. And secondly, there doesn't have to be a diminished economic interest or a diminution in the value of the property in order for it to be a taking. It's simply the regulatory mandate that you allow someone onto your property in and of itself is a taking for which you're entitled to have compensation. What the compensation is when there's no economic activities being diminished is a different issue. That's a measure of damages. It seems to me that that's directly relevant here with respect to whether the FAA can be authorizing commercial drone operations, setting commercial drone routes in low altitude airspace over your property.
Okay, so the idea would be in the secede case, and I'm glad you brought it up. The state government gave essentially a permanent easement to labor organizers to private land. And the analogy, could be, one lesson, someone might take from that is that no government, could give a permanent easement to low altitude airspace above someone's land that possibly under Hasid could resemble a taking by any government who purported to give that access right. Is that right?
But one of the problems is drawing the line, because at 10,000 feet, no one's going to be arguing about a taking or a trespass.
Right.
So that's the
That's right.
that's the gravamen of our problem. Really.
No, but at 10,000 feet, it's a public highway. I mean, on the Cosby,
it's clearly
on the Cosby, we know that it's only low altitude airspace within the immediate reaches of the land that is a private property right.
But what I'm saying, Reggie, is, do we draw it? Is the line drawn at 83 feet? Is it drawn at 300 feet? Is it drawn at 500 feet? That's
no question is a line to be drawn.
Yeah.
What constitutes immediate reaches? And that issue has never been resolved either as a matter of case law or as a matter of FAA regulation. But there is an effort now underway in Congress to begin to address those issues.
Yeah, let's talk about line drawing, because this is an important issue in this area of law when it comes to federalism and how states and the federal government will complement each other when it comes to drones. And just to put it, from the position of a landowner, you could imagine the day, and there are some cases of this where you have some rural property or suburban property, and one day some buzzing drones are flying to drop off packages, perhaps for testing, perhaps a pilot commercial service. And as I said, many people intuit that's some kind of trespass or some kind of invasion of their privacy. And many states have codified that people do own the airspace above their land. I don't think any state has put a cap on that, which gets back to the line drawing exercise. But all that to say, this seems to be the conflict. Many landowners intuit and many states codify that people do own some amount of airspace above their land. And then you have the commercial drone industry who want to provide great new services to the American people, but obviously do not want to have to go property by property and pay some rental fee or something. And you have the FAA also, who is a safety regulator, wants to make sure this is all standardized, and also want to some extent see this aviation sector succeed. So they all have different and at times conflicting interests. So let's talk about line drawing. Is it fair to say under many state laws, people do own the immediate reaches above their land. Is it fair to say that?
Well, it's fair to say there are enactments that reflect
say
and
that.
codify that. A different question as to whether they're valid and would be recognized or not. But the most ambitious effort so far to try and draw a line is a fairly recent proposal from Senator Mike Lee, proposed legislation. It builds upon some bipartisan legislation from 7 or 8 years ago that Richard Blumenthal and Dianne Feinstein and Mike Lee and one other were a part of. The most recent iteration of that is Mike Lee, so far is Mike Lee alone. But Charlie, why don't you talk about that? Because it is a fairly significant attempt to bring clarity to an area that has never really been joined and resolved.
Well, it would essentially, and you correct me, Reggie, if I have this wrong, but I think essentially it would reserve up to 200 feet as the immediate reaches of the atmosphere, or immediate reaches of the airspace. That's how the statute frames it. And so with that, it would clearly delineate that portion of the airspace to the landowner. So it's an attempt to make a allocation of the airspace by governmental, dictate.
And to be frank, I think there's a lot to recommend that model of drawing a line. Perhaps it's 200 feet. Reggie, you mentioned there's various proposals. 400 feet, 50 feet.
Yeah, and the statute, the proposed statute, the bill would create an intermediate zone of 200 to 400 feet, which would be treated differently from the airspace above 400 feet.
Yeah, kind of traditional aviation.
Yeah, I mean, it's important to recognize line drawing is inherent in aviation regulation. Every flight path is a line that's being drawn in the atmosphere. And Part 107, which mandates the operation of drones below 400 feet, is drawing a line. So lines are not new. I mean, they're a part of aviation regulation. So the real question is...
And the airspace is divided, for FAA...
Class A,
air
C,
traffic
right.
control purposes, it's divided into various zones.
Based
B
on-
airspace, C airspace, D airspace.
based on heights and distances. So there's nothing new here. The question is, for the first time, is an attempt to define. And once you define the low altitude airspace, as Charlie said, as Senator Lee is proposing at 200 feet and below for the low altitude drone operations. The part two of that is that for the first time, state and local governments will have exclusive regulatory authority over the time, the place, and the manner of drone operations 200 feet and below.
Right. I believe the statute would even, in effect, exclude them from the Airline Deregulation Act insofar as they're carrying on that function.
Right, and that's an important point. The Airline Deregulation Act was 78.
78, yeah.
State and local governments, you have no authority when it comes to fares, services, or routes. And
Except for airports.
yes,
They have their residual power to locate airports.
Right.
Yeah.
And this is an explicit repeal of that restriction with respect to state and local governments. And it's basically says state governments 200 feet and below is for you. It doesn't vitiate the safety authority of the FAA. So the FAA would still have authority with respect to things like certifying the airworthiness of the drone, the flight control systems, the detect and avoid, the communications links, a whole panoply of regulation with respect to the safety of the drone delivery operation is still within the control of the FAA. It's just the time, the place, and the manner of the drone operation will be set by state and or local governments.
It might be helpful for the audience to just get a little bit of background in terms of how that lower airspace activity could be governed. So, most people are familiar with air traffic control and how it works with commercial aviation. That would not be feasible for this low altitude traffic at 400 feet and below. And one of the things that the FAA and other agencies and people have been working on is UAS traffic management, a concept which is based on the ability of drones to communicate with one another and to a central authority, giving their positions, their their intentions, their course, and that sort of thing, to in effect serve as an air traffic control system, probably autonomous at this low altitude area, in this low altitude realm. So, that's something that has to happen before, that has to be developed both as a technical and as a regulatory matter before, our sort of mental image of drones doing all these deliveries 24 hours a day, 7 days a week could happen. So one question that arises, what role would the states or local authorities have in that system? And how does that contrast with traditional air traffic control?
Yeah. Well,
and then a second point that I would make, just to sort of flesh the whole thing out, is we're talking about two things which are two ends of the spectrum, two poles. One is the very low altitude airspace, 400 feet and below, where small drones are operating. The other is the traditional airspace where large commercial aircraft are operating. But there will be an intermediate realm as well, where so-called AAM, advanced aviation mobility vehicles such as so-called air taxis will operate, and larger drones carrying larger cargoes, say 50 or 100-pound cargoes, will be operating both at a higher altitude and also transitioning to the regulated altitudes where commercial aviation operates.
It's an important, Charlie is raising a really important point, and that is the airspace is getting increasingly more complex. We already have very complex airspace in the United States because of the volume of operations. But it's getting, that complexity is magnified by the entrance of all types of new aircraft and new operations that haven't existed before. And so one of the fairly powerful arguments against the view that I think we both are embracing, I certainly embrace, one argument against it is that in that degree of complexity, there ought to be a central manager or central control of airspace. And it ought to be, because it's the FAA for manned aviation, it ought to be FAA for the unmanned side as well. Witness what happened at National Airport when we had just commercial aircraft and helicopters operating too close. There was an accident. And so that's not an insubstantial argument at all. I don't find it outcome determinative, not only because I have faith that the technology for a traffic management system for UAS will be developed and ultimately can get integrated in with the current flight management, traffic management system with manned aviation. That's an important consideration, but also because precisely because of the complexity, I think Mike Lee's right. We ought to take from the FAA something and bring in a new set of resources. And I think he's right. It ought to be the state governments.
Yeah, to state it another way very simply, I mean, how much can the FAA do? It's already managing this very complex, the world's most complex airspace, commercial airspace. It's the aviation safety regulator as well. And, if it then has to take on the additional task of regulating every drone movement in every city and town and suburb, there are just practical limits to what one organization can or should be doing, too.
Yeah, and the claims, to go back to where we started, things around noise, things around terrain, things around micro weather patterns, who better than state and local governments to become familiar with the unique aspects of the airspace where those low altitude commercial drones are going to be operating, and who better to adjudicate what happened in College Park, Texas, which is what we thought was going to work out well, didn't work out well. And so there was a great resolution because Amazon stepped back and said, well, we need to redesign this drone and we need to move our logistics warehouse. And they did. So there's a general conception that state and local governments may be antagonistic or hostile to drone regulations. And so there's almost a reflexive perspective that we want a single regulator. But that case illustrates that when the landowners, through their state and local governments, work with industry, there's a resolution. And the resolution took place at the state and local level. It didn't take place in Washington, D.C.
And remember, in highways and surface transportation, state and local authorities are the primary safety regulator, right? I mean, they're the folks who write the speeding tickets. So,
right. So I'd like to get back to line drawing as we wrap up, because that seems to be a core issue here, and in many ways, this uncertainty about who owns low altitude airspace, what's the federal interest, what's the state interest. The Congressional Research Service, I think USDOT, IGs have pointed out that this uncertainty about who owns it, who manages it, has harmed the drone industry to some extent. And I've full disclosure, I've always been partial to the line drawing idea that someone, whether Congress or perhaps Congress, draws a line 200 feet or so, recognizes that below that you need permission from a landowner to fly, or it's and above that, there's something like clean airspace for interstate drone operations to commence. I think that clarity would be great. I think the Uniform Law Commission tried to do something like that a few years ago. I mean, Senator Lee has tried to do this. So while it looks very simple and elegant to me, there's a lot of opposition to it. I know. Can you speak to the drone? I don't know. It's hard to lump them all together, but can you speak to the opposition from drone companies and the FAA to this kind of line drawing proposal?
Well, I won't speak for the drone companies. Sure. As for the FAA, I mean, I think they are in the line drawing business, and so I'm not sure that they would disagree with the line drawing exercise. Let me leave it there.
Reggie, do you have anything to add on that?
No, I'll let the industry and the companies speak for themselves. They've been fully engaged in all these debates at the various forum in which these debates have occurred.
Yeah. All right. And then go ahead.
I would suggest that there may be alternatives to the government allocating airspace. If that's where this is ultimately going, the government allocating airspace, which it does for aviation safety purposes at the higher altitudes. But if there's going to be an exercise of government allocation of airspace at the very low altitudes where drones and other vehicles like the AAM vehicles may be operating, one alternative to consider is a market-based allocation as well, and that may resolve some of the problems.
One thing that has happened at the state government level is a number of states have actually passed legislation taking these issues away from local governments. That's been in a number of states, with a wrinkle that in some states is what's called home rule. So large cities tend to have some sphere of independent legislative authority. But generally speaking, the states have responded to this development by requiring that these issues be dealt with at the state legislative level, not in the local communities.
Yeah, and I think that makes a lot of sense.
But just to follow up on Reggie's Dallas example, I mean, let's assume the line is set at 200 feet. That's Senator Lee's proposal. You can imagine a situation where, it's been made clear 200 feet and below, it's the property of the landowner. 200 feet and above, it's a transit way for drones. But the landowner is still not happy because he hears the buzzsaw or whatever it sounds like to him when they go over at 300 feet. So I guess what I'm saying is it's not necessarily so that intelligent and rational line drawing will actually resolve all of the issues.
No, and there is a distinction to be made between the standards of proof for a regulatory taking and the standards of proof for a simple trespass. And a simple trespass may not be the answer. We developed a whole body of legislation of tort law in response to the advent of the automobile. We never had automobile accident claims, and we'll end up developing a body of law with respect to the invasion and use of airspace without permission of the landowner. I don't know that trespass is the right standard. We can develop that as we need to.
Okay, and before I ask you my final question, I'd like just is there anything else the audience should know? Are there court cases or policy trends that are of interest that you followed that you think the audience should know? Reggie?
The only thing I'd say is that in the last 7 or 8 years, there were a series of state court cases challenging state legislative enactments. Generally, in 3 or 4 of those cases, the judges, in dicta, they were opining, having nothing to do with the resolution of the case. No, they weren't articulating a new rule or anything, but they were reacting to the assertion that the federal government controls all airspace down to the tops of the blades of grass with dismay. They thought that was at least aggressive, if not ultimately perhaps indefensible legal position. As I said, those were a handful of early cases. There have been 1 or 2 other cases where the one party or another tried to very expressly raise the issue as to where the line is drawn, and the court finessed and resolved the case on a different basis, one in Michigan. So the answer is no, there really isn't a body of law yet. There's some people chomping at the bit to try and develop a body of law, but it hasn't happened.
I think it's actually surprising that there are as few cases as there have been that address this head on. And I agree with Reggie. Judges, federal and state, from what I can see, have for the most part been skeptical that the FAA, could control all aviation activity through every altitude. And I think it's fair to say that, historically, the courts have found that Congress has preempted the field of aviation safety largely through the FAA, but not the entire field of aviation. I don't think the courts have gone that far traditionally. So, I think it's an open question as to where the courts will go with whatever legislative solution is arrived at.
Yeah, I agree with that. Courts, when these issues do come up, the preemption issues, they tend to be skeptical that the FAA is entirely preempted states, aside from safety, but in other areas. Yeah, I'll point listeners to there's one case a couple years ago, the Fifth Circuit, NPPA versus McCraw, and in that case,
right,
Texas had created drone exclusion zones, I believe, above sensitive infrastructure, power plants and dams and so on. And some drone operators sued and alleged that the field had been entirely preempted by the FAA in the Fifth Circuit, and District Court rejected that. But that's one circuit, and there are some other cases bubbling out there. But my final question for you is: so you're both Chief Counsel of the FAA. We have a new administration, new policymakers. Is there advice for an FAA administrator, or Chief Counsel, or Congress that you would most want to leave them with when it comes to this very confounding area of low altitude airspace?
Well, just sort of general advice, I'll get back to my point that I think there's only so much the FAA can do, and that it shouldn't be shy in allowing those responsibilities to be shared as this new realm of aviation opens up, and shared with local and state authorities and maybe others. I think that there are, the other thing I would say is that we should never forget that our people here in the United States are, among the most creative and adept at problem solving as all the people of the world. And we, including the FAA, should unleash them and, bring their talents to bear on some of these problems. And so lifting the regulatory burden is, always going to favor that.
I very much would like to see either Senator Lee's proposed legislation or used as the opportunity to engage in a comprehensive discussion. If not through a set of hearings, then let the FAA, through a proposal, a request for information, begin to flesh out what is an appropriate new legal and regulatory framework for the management of low altitude airspace in this age of commercial drone delivery. it ought to happen not in the context of any specific regulation. When we did Part 107 almost 10 years ago now, we expressly reserved speaking about privacy and low altitude airspace management issues. It needs to happen, and I don't know where the forum is and what the vehicle is for that conversation, but we've been nipping at around the edges for a long time, and it's time to really engage the conversation, figure out what is the new appropriate framework.
All right, thank you for that. And I want to thank listeners for joining us for this discussion about drones and federalism and FAA regulation. And I want to thank Reggie Govan and Charlie Trippe, who were both Chief Counsel of the FAA in the past decade. And I want to thank you for your time. I'm Brent Skorup, the Cato Institute, and I also want to thank Federalist Society and the Regulatory Transparency Project for hosting this discussion. Again, this is part one of a three-part series about aviation, regulation, and regulatory reform at the FAA. Thank you.
Thank you.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.